Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated.
We are ready to hear arguments in our first case on the docket, and apparently we have a short docket today. Our first case on the docket is United States versus Abigail Pierce. We're ready to hear from the petitioner.
May it please the court. Good afternoon. My name is Evan North, and I, along with my co-counsel Lindsay, represent the United States of America, the petitioner in this case. I will argue that the good faith exception to the exclusionary rule should apply in this case, and my co-counsel will discuss the apparent authority doctrine. As to the first issue, the United States respectfully requests that this court reverse the judgment of the Court of Appeals for two key reasons. First, the good faith exception to the exclusionary rule should apply when an officer makes an innocent mistake of fact in identifying the wrong suspect.
Are you extending the holding in Leon?
Your Honor, just as the court recognized last year in Herring versus the United States, the good faith exception can apply to a variety of situations, and yes, this would be an extension of that same rationale for Leon.
But isn't our case different from Herring?
Yes, Your Honor, absolutely. This case is different in that the mistake was made by an officer in the field. In other cases, such as Herring, it was a police employee, a warrant clerk at a sheriff's office.
Away from the scene, a place where you would go to get information.
Yes, Your Honor, that is correct.
Much like a court record. And so don't you see a difference there?
Your Honor, there is a difference there, but however, there is the possibility that an officer in the field could make a mistake that is objectively reasonable, and another officer could rely on that mistake in forming reasonable suspicion, such that the deterrence benefits of exclusion are insufficient in that type of case.
Well, who made the mistake here?
Your Honor, in this case, it's possible to see the mistake in two different ways. Agent Jones was the officer who came to work with knowledge that she might have an issue with colorblindness and identified a suspect based upon the color.
Isn't that a problem? That as a police officer, you go to work not sure if you can see?
Your Honor, very well, that is a problem, and it's quite possible that that is a problem that can be deterred. However, the exclusionary rule is somewhat more demanding than that. The exclusionary rule doesn't simply ask whether there could be any deterrence in the case. The exclusionary rule demands that there be substantial deterrence such that it overcomes the substantial social costs of excluding evidence in a criminal case.
But if we exclude the evidence in this case, wouldn't that cause police departments to sharpen their review, the physical review of their officers?
Your Honor, it's very possible that that would be a deterrence benefit in this case. However, it might also have the effect of causing officers to second guess whether they could discharge their duties effectively if they have so much as a head cold. In this case, Agent Jones was not aware of the seriousness of her condition. She was on notice that she might have an issue with colorblindness. Common knowledge about colorblindness is that it usually causes you to confuse the colors of red and green. She was identifying a suspect based upon either a blue shirt or a green shirt. And in the situation, that was the only way for her to discern the difference between these two women who looked very similar on a crowded college campus. So it was a reasonable mistake for her to make without the knowledge that she actually had a serious and rare vision deficiency that caused her to confuse blue with green. So in this case...
I'd like you to go back to the question that the Chief Justice asked here right before that. Who do you see as the person who made a mistake here? You started to say maybe Jones. What about Mendez?
Well, that's a complicated question, Your Honor, because as Leon instructs us to do, we have to look to the reasonableness of all of the officers involved here. And one could argue that Agent Jones made a mistake in identifying the person based upon the color of the shirt. One could also argue that Agent Mendez made a mistake in relying on that identification. It's more likely that it is the case that it's Agent Jones that we need to look to. However,
it's not Agent Jones that stopped the individual.
That's
Isn't
correct.
that where the rubber hits the road when you're talking about Fourth Amendment violations?
Your Honor, that's true, and it is the case that Agent Mendez, as the person who stopped the individual, who seized the backpack and filled out the warrant affidavit, is also important to look at here. Agent Mendez independently knew what Daphne Evans, the true suspect, not the respondent in this case, did look like. Agent Mendez had followed her twice before, so he could just as easily have been relying on his own previous knowledge of what Daphne Evans
But
looked like.
didn't he say that as he got closer to her, he wasn't certain that it was the right person?
That's true, Your Honor. That is in the record. However, in initiating the consensual encounter with Miss Pierce, he gained other information that overcame that uncertainty that he had as he approached Miss Pierce. That included information that she had just come from a suspected drug dealer's apartment building, but she didn't say that to him. She said that she'd just come from spending hours studying in the library. Just after lying about her recent whereabouts, she gave her name as Abigail Pierce, a name that Agent Mendez was not expecting. And this court held in Hill v. California, or rather they recognized in Hill v. California, that a false identification is may often serve as the basis for someone trying to evade arrest.
But that was her true name.
That was her true name, but under the circumstances, it was reasonable for Agent Mendez, knowing that she had just lied about her recent whereabouts, to suspect that she also might be lying about her identity. This, coupled with the fact that she was being evasive when he was following her, she ran into another student on campus, bumped him over, and
She's a young woman on campus. It's getting toward dark in the evening. She notices someone's following her. How did you expect her to respond? She looks over her shoulder, she sees this man, and she speeds up and becomes nervous and runs into another student.
Your Honor, it's certainly possible that that was a reasonable response. And that certainly...
Mr. North, you're not contending that absent Jones's information, Mendez would have had reasonable suspicion to stop her and seize her backpack, correct?
Actually, Your Honor, the government does contend that there would have been reasonable suspicion to detain the backpack for a brief investigatory stop, as this court recognized.
Even without Jones's information. In other words, if Mendez has simply been involved in an ongoing investigation and sees someone whom he thinks is Evans, who he has some generalized suspicions about, you think he could have stopped her then under these circumstances because of her hurrying and looking over her shoulder and so forth?
Your Honor, not necessarily because of those facts, but more importantly because of the fact that she had lied about her recent whereabouts, that she gave a name that he didn't expect, and that he had his own independent basis for believing that it was someone who had been associating with a known drug dealer. That should have risen to the level of reasonable suspicion that this court required in United States v. Place for a brief investigatory detention of luggage.
So under your argument then, Jones's mistake is irrelevant?
Your Honor, in the alternative, if Jones's mistake is important, then the good faith exception does pose a case for extending the good faith exception to an officer mistake.
Mr. North, you've already indicated that most of these cases where we found this exception are not near the search and it's by a third party. What is the best case that you can provide us that indicates that we should extend this exception to a mistake made by the officers themselves?
Your Honor, the 2nd, the 5th, the 6th, and the 8th circuits all have encountered situations much like this. The 5th Circuit in United States v. De Leon Reyna looked at a situation where an officer was stopping someone who he had an objectively reasonable belief had been involved in drug activity. And however, that ended up being not the case, but his belief that he had reasonable suspicion was a reasonable one because it was in good faith. And the court there looked to the fact that it's impossible to...
Well, there's a difference between a good faith mistake and an outright error. An error that took place in a case like this. Can you give me an example of an outright error that was made by a police officer where we extended the exception?
Your Honor, I'm not aware of such a case. However, in the similar cases of Herring v. United States, where there was an outright error that was made by someone, albeit attenuated and away from the scene of the crime, that error, it was reasonable to rely on it for the officer in the field. And here we have the same situation where there is an objectively reasonable reliance on a mistake of fact that renders, even if it does render the search to be unconstitutional, it's important to recognize that the deterrence benefits simply don't pay their way in such a case because you can't deter reasonable officer conduct.
Do you concede that the clerical employee of the police department being away from the scene, so to speak, in fact, is a distinction between hearing in this case?
Yes, Your Honor. It certainly is a different set of steps.
Why?
Well, simply because it does involve a different government actor. But this does present an opportunity for the court to recognize that it's the character of the conduct and not the job description of the government employee that is the critical inquiry. In hearing, it was someone who was away from the scene. But here, there's no reason to think that an officer on the beat could not also make a good faith mistake of fact, and a partner would rely on that good faith mistake of fact.
So what you're conceding is there is a difference in fact, but you don't think that should make a difference in the outcome. Is that right?
That is correct, Your Honor, because the rationale dating back to Leon, the inception of the good faith exception, has been extended to various circumstances, and it's clear that in that long march of cases, applying it to different fact scenarios, that the court is looking to the character of the conduct.
Well, in all of our cases, from Leon down to Herring, we have had a difference in location between the officer making the stop and the information received, whether it was from court or from another officer. What would you say to the situation where you have no second person involved? You merely have Mendez, who is looking for somebody, and he stops them. He's made a mistake. He's misidentified them. Do we have a Leon there? Or do we say, oh, that's different because it was just him?
Your Honor, that does present an entirely different set of facts, and it's possible that you wouldn't have a good faith exception case.
So you have to rely on information from some other source. Is that where we would draw the line in this case?
Certainly, Your Honor, that would be a good place to draw the line in this case, because of the fact that the mistake of fact was made by one officer and then relied on objectively by another officer. And such a rule would encourage police officers not to second guess the judgments of their partners in conveying information to them, and would enable them to rely in and make that reliance objectively reasonable on information communicated by fellow officers. The reason this is so important is that the crux of the good faith exception is that objective good faith behavior or minor transgressions are not susceptible of deterrence. And that initial understanding of the exclusionary rule and the purposes of the exclusionary rule should apply the same as in this case as it has in the past. It's a demanding remedy, and it should only be applied when the deterrence benefits severely outweigh the severe social costs of suppressing criminal evidence.
So we have to have willful, outrageous conduct. We can't have just negligence.
Certainly, Your Honor, willful, outrageous conduct is what led to the exclusionary rule being developed in the first place. The court in hearing did speak to whether negligence would trigger the exclusionary rule, and they said that it would have to be isolated negligence in order, it would have to be recurring or systemic negligence in order to trigger the exclusionary rule.
And did the dissent point out in hearing that there was repeated problems with the information that was obtained as regards outstanding warrants?
Yes, Your Honor, the dissent did make that point in hearing. However, the majority...
So maybe we have the same problem with this police department. We have whole bunches of people that are colorblind.
Do we have that in the record, Chief Justice?
I'm asking you.
Your Honor, there is no information in the record to suggest that this was a recurring or systemic problem. Actually, Justice O'Connor's concurrence in Arizona v. Evans provides some guidance as to whether where to draw the line between recurring and isolated negligence. While she agreed with the majority in that case that the isolated negligence of a court employee should not trigger suppression, she said that it wouldn't be reasonable for a police department to continually rely on a warrant system that produced false entries. So that type of recurring negligence is what would be required in order to trigger the exclusionary rule. The reason for that is that even if it's possible to imagine marginal deterrence benefits in this case, that's insufficient because of the social costs of suppression. And here the social costs are painfully obvious. The fact is that this college campus has been stricken by drug overdoses that have led to 3 student deaths.
So police can stop whenever they want?
Certainly not, Your Honor.
I mean, when you speak of societal costs, you have to look at whose society we're looking at. If you're looking at an isolated case and you're concerned about this person whom you've caught and you've found a lot of drugs on this person, then you say, oh my God, we shouldn't let that person go. But if that person had nothing on them, what about that societal cost?
Your Honor, I see my time has expired. May I have leave to? Your Honor, in that case, if the person had nothing on them, or if the officer did not have anything close to reasonable suspicion, certainly that would not trigger the good faith exception, and that evidence should be suppressed. The line should not move from reasonable suspicion. However, it's possible that, as in this case, an officer believed he had the requisite level of suspicion, and he had that belief in objective good faith, and that type of conduct is not susceptible of deterrence because of its reasonableness.
Thank you, Counsel.
Thank you.
May it please the Court? Good afternoon. My name is Lindsay, Grise, and I represent the petitioner, the United States of America. As indicated by my co-counsel, my discussion today will focus on the issue of whether the apparent authority doctrine should hold constitutional the search in this case. Your Honors, we respectfully ask this Court to reverse the judgment of the 13th Circuit for the following two reasons. First, Ms. Pierce's roommate had apparent authority to consent to a search of the computer.
How far did that apparent authority go to someone hearing what Ms. Lee had to say? If you'd walked into that room and you'd seen and heard that, what would you have thought that Lee had the right to do?
Your Honor, the officer in this case entered the room. He knew that Ms. Lee was Ms. Pierce's roommate, and they shared a single room, small dorm room. The computer was centrally located, and the computer was turned on and lit when Ms. Pierce had not been present for over 4 hours. Those facts alone reasonably indicated to any officer that her roommate enjoyed open access to this computer.
The computer was not on her desk, right?
Correct, Your Honor.
And was that known to the officer?
Yes, the officer asked whose computer was on this desk, and she responded, "That's my roommate's computer." The officer then asked, "Do you have access to this computer?" And she said, "Yes, I use it several times a week for school projects." At that point, with the computer being turned on and lit, the central location in a common shared area of the dorm room, and the fact that the roommate used the computer several times a week, which is completely consistent with the frequency one would use a school computer, that reasonably indicated to him that Ms. Lee enjoyed joint access and mutual use for most purposes. And even when a password prompt appeared, which reasonably called into question the roommate's level of authority, the officer stopped and asked more questions, specifically calculated to confirm the roommate's authority.
And what did he find out when he asked that question about the password?
Yes, Your Honor. He asked, he was unfamiliar, the record states that he was unfamiliar with the password prompt, and so he stopped and asked, are you familiar with what this password prompt is? Ms. Lee stated that Ms. Pierce had installed Folder Protect Expert software on the computer, which allowed users to password protect folders. Then he said, "Do you have access to this folder?" Her very next statement was, "We exchanged passwords." The common interpretation...
But she didn't go any further than to indicate there was exchanging passwords to that folder, is that correct?
That is correct, Your Honor. But
and the implication from the software that this was password protecting folders should have left the inference there that there were other passwords for other folders which may well have been protected that she had not had access to, right?
Your Honor, I would agree with you if she had simply stopped after saying, "My roommate installed Folder Protect Expert, which allows users to password protect folders." Perhaps that statement, viewed in a vacuum, would be sufficiently ambiguous that would require the officer to inquire further. However, her very next statement saying that we exchanged passwords, the common interpretation of that statement is, she gave me her password, I gave her mine.
Did he ask her, though, what that meant?
No, he did not, Your Honor, but he did ask her how many times she had accessed this folder. She then stated that she had accessed the folder on several occasions when one roommate was running late and needed a file sent out of that folder.
In other words, in sort of emergency circumstances, she didn't sort of have a carte blanche to access the folders. She had the authority on emergency occasions to access the folder to expedite getting something to her fellow student's class, correct?
Respectfully, no, Your Honor. She never used the word emergency, and she never said the only time that I can get into this folder is for this particular purpose.
But it was only the one folder, isn't that right?
Yes, yes, Your Honor. She was talking about her access to this one particular folder.
So the officer then knows in order that there was a program put on the computer that protected folders,
Yes.
and that there were at least one password protected folder, and probably all of them were password protected, right?
The record does not indicate whether he thought that there were other password protected folders or whether this was the only folder that had password protection that the roommate
But I
could
thought
use.
that was the whole purpose of the program that she put on her computer,
The
to protect all folders.
Your Honor, the record does not indicate that Ms. Pierce installed this software to password protect all folders.
Right,
And-
that isn't the right inquiry. What should the officer have thought about when he found out that there was a password protect program installed? In other words, doesn't that put him on inquiry notice rather than moving to a forensic program which gets in and gets behind whatever might be there? Doesn't he have an obligation to take that next step and find out whether there are other passwords which would show a heightened expectation of privacy?
Yes, Your Honor. If he had simply stopped his inquiry after learning about this software and used the forensic software to search the computer, that would have likely been an unreasonable search of this computer. However, in the personal computer context, passwords are not as common as computers in other contexts, such as a military computer or a computer at one's office. One could expect...
Are you kidding me? You don't have a password on your computer?
Yes, Your Honor, there's one log-on password, but to access documents on my computer, I do not have other passwords, and it's not reasonable to assume that there are in the personal...
But in fact, doesn't that really kind of turn itself on its head? Because it is unusual to have passwords in that way for different folders. The very fact that she had this program that clearly did protect at least this one folder, shouldn't he have asked more to find out whether or not the roommate shared the same kind of access which the record reflects she may have had to this particular folder?
Your Honor, again, if he had simply stopped his inquiry after seeing the password prompt or learning about the capabilities of the software, that would have likely not been reasonable. He had a duty to inquire further. But her very following statement saying, yes, my roommate installed this software that allows users to password protect folders. However, we exchanged passwords. That cleared up any ambiguity in his head, and the roommate, having been so forthcoming with consenting to the search and giving him information, withheld information which would have allowed him to learn that there were other folders on this computer.
What is your best case that would cause us to reverse the circuit?
United States v. Morgan was a very similar case involving a computer consent search involving apparent authority, where a wife stated that she used the computer just to play solitaire or computer games, and the husband actually had a different sign-on password and other password-protected folders. The court in that case really focused on the fact that she did not tell them about those other password-protected folders, and the fact that the computer was turned on and lit when they entered the room, and she said she used it to play solitaire, and that provided sufficient authority in the officer's mind.
Is there exigency here? Why didn't you get a warrant?
Your Honor, there was no exigency here, and a warrant would have been required absent the consent.
Well, counsel, that's the question I have, which is that it's obvious that this was an ambiguous situation. I don't see the emergency need to apply this exception. What's the policy reason that you would advocate to allow the exception in this case?
Your Honor, consent searches are a valuable, important police tool that police use frequently. When a party grants consent, the police can search the container or the premises. Furthermore, data stored on a computer is unlike a paper in a file cabinet. A paper in a folder in a file cabinet would not change. It would not, could be months, years, that paper will remain constant. Data stored in a computer is very different. The zeros and ones stored on a computer hard drive are continuously changing. And with hackers and the very manipulation of electronically stored data, it's important for police to be able to create a mirror image copy of data stored on a computer to preserve the integrity of that data for a hopeful trial of the suspect.
Are you suggesting that this was not an ambiguous situation that required the officer to inquire further, or are you saying the officer did inquire further? What's your position?
When the password prompt appeared, that did create an ambiguous situation that if he had not inquired further, that would have been unreasonable. The officer did inquire further, ask questions specifically calculated to confirm her authority to use the computer. The common usage of personal computers is very different than computers in other contexts, such as a military computer, where it would be easy to expect, at a minimum, multiple layers of security. In the personal computer context, passwords, they're not like cockroaches, where when you see one, you know another must exist. The officer saw a password prompt he was unfamiliar with, reasonably responded to that password prompt, asked questions that were specifically calculated to confirm her authority. She stated, I've gotten into this folder in occasions where one roommate's running late and that she needed a file sent. She never said, I only can get into the folder for that purpose. She never said, oh, it's only an emergency purpose.
But that's not the folder where the information was found. Isn't that the problem?
Yes, Your Honor, and the fact that the information was found in a folder without, where the roommate did not have access, makes this as an apparent authority case, because she did not have authority to grant consent in that particular folder. However, in every apparent authority case seen before any court, one could imagine the one magic bullet question that the officers, in hindsight, could have asked that may have resolved the ambiguity. This court's jurisprudence in using a totality of the circumstances analysis and requiring officers not to be perfect, but just to be reasonable in all cases, sufficiently protects one's Fourth Amendment privacy interest in this computer.
And again, you say you didn't get a warrant because you thought something would be changed on the computer.
Your Honor, the officer did not get a warrant because the roommate granted consent to search the computer, and she had the authority, in his mind, reasonably to do so.
What's the best case that counters your argument where you rely on Morgan?
Yes.
What is your opposition going to cite to us?
My opposition would likely cite to United States v. Block, where a mother consented to a search of a bedroom, her son's bedroom, and the son had a locked footlocker under his bed. And the police went in, pried open the lock of that footlocker, and the courts there said...
And isn't our folder just like the locked footlocker?
Respectfully, no, Your Honor. In the case of United States v. Block, the officers went in and saw the physical walls of a footlocker and were able to see the physical lock that locked that footlocker. Here in the metaphysical world of computers where
there's no expectation of privacy when you have something on your computer that's protected by a password?
Your Honor, the situations would depend whether or not a simple application of a password would clearly manifest an expectation of privacy. Here, in the very nature of a shared dorm room, there is little to no privacy. And if Abigail Pierce had truly wanted to protect the integrity and privacy of the documents on her computer, she should have simply restricted access. United States v. Matlock discusses that when one invites a third party into their private areas or to see their private containers, this chips away at the reasonable expectation of privacy. You run the risk that that third party will show what your things that are private to somebody else.
Well, that certainly may be true in terms of the general opportunity to take a look at the computer, but isn't it unrealistic to say that a person in Ms. Pierce's position had to either pick one side or the other, either totally restrict Ms. Lee from using the computer or else just it's open to the world? I mean, she did what she could do. She password protected her documents in there, and some of them she allowed Pierce access to, and some of them Lee access to, and some of them she didn't there. And it seems to me that that isn't quite the same as saying, well, she just opened the doors by the computer on. Why is that? Why does she have this diminished expectation as to those things which she did take care to protect?
Your Honor, the record reflects that there was this one folder to which Lee did not have access on a desktop filled with 30 or so file folders. United States v. Matlock discusses that when you let someone have such unrestricted, seemingly unrestricted access to the majority of your computer or container or premises, the inquiry comes from where the officer is standing. And when this officer looked at this computer, the computer was turned on and lit, reasonably indicating to him that Ms. Lee used this computer as she would, and Ms. Pierce was not present and had not been present for 4 hours. Your Honor, I see that my time has expired. May I finish my thought? Coupled with the fact that Ms. Lee stated to the officer she used this computer several times a week, and when a password prompt appeared, she had the password. In the mind of any reasonable officer, the inquiry was over and the ambiguity was resolved. Thank you, Your Honors.
May it please the court. My name is Milos, Jekic, and I, along with co-counsel Daniel Buller, represent Respondent Abigail Pierce in this matter. I will be addressing the applicability of the good faith exception to the exclusionary rule, while Mr. Buller will address the third-party consent to search issue. This court should hold that the good faith exception does not apply in this case for two reasons. First, there was no police reliance on a neutral third party. Second, even if such reliance...
Was there reliance on a neutral third party in hearing?
Yes, Your Honor.
How do you square that with the fact that that person worked for the police department?
The person upon whom the police in hearing relied worked for a police department in a different county, in a neighboring county. It wasn't the police department that was in fact making the arrest. It was a different police department not intimately involved in the investigation and the arrest of defendant hearing.
Why should that make a difference?
This court's jurisprudence, starting with Leon and beyond, has made it fundamentally important for the applicability of the good faith exception that the police reliance be on a neutral third party. That aids in the objective reasonableness of the police conduct because the neutral third parties have less of an incentive potentially to violate the Fourth Amendment in the competitive enterprise of ferreting out crime.
Why would that apply, though? Once you start getting into law enforcement generically, given all the cooperative investigations and cross-jurisdictional efforts that go on here, isn't that a distinction that really fades away in this contemporary time to try to isolate this other police department as truly independent?
No, Your Honor. They are still different police departments, and the police department that had maintained the warrant database in hearing was not involved in that case. They may have a generalized interest in prosecuting crime and in arresting individuals who are guilty of crimes. However, they aren't intimately involved in the case at hand. And that fundamentally is the key question as far as the reliance by the police in the field in terms of applying the good faith exception.
Counselor, what is the purpose of the exclusionary rule? Why do we have it?
The purpose of the exclusionary rule is to deter police misconduct.
Okay, so if you have a situation here where you have an officer who is only has slight knowledge of the vision problem and no knowledge of having this rare colorblind condition, and another officer who has no knowledge of this problem and is relying upon that information that receives from that officer, what conduct are we deterring?
The conduct that is being deterred, starting first with Agent Jones. Agent Jones was informed that she might have an issue with colorblindness. Despite her awareness of the potential risk, she went out into the field and pursued an activity in the case at hand, surveilling Mr. Patel's apartment that was fundamentally predicated on her ability to perceive visually.
So you think that's willful and reckless?
Reckless.
It's beyond negligence?
Yes, Your Honor, it is beyond negligence. It is reckless because there was an awareness of the risk and a conscious decision to act despite that awareness of the risk by Agent Jones.
Well, what was her awareness of the risk? How heightened was that awareness?
She was aware that she might have an issue with colorblindness. That was the extent of it. She was not aware that she definitively had it, and she wasn't aware of the severity. But she was aware that she might be impaired in her ability to perceive visually. And despite that awareness, she did go out in the field and do just that, make an identification based specifically on her ability to visually perceive. In particular, she identified the woman coming out of the apartment when she radioed to Agent Mendez. She identified the woman based specifically on the color of the shirt. Now, that was not the only way in which the two women in question could have been differentiated. The two women that exited the apartment were, in fact, for example, walking at different paces. The one was walking faster than the other, and they were in different positions. Yet, Agent Jones chose to identify the woman based solely on the color of the shirt. The color of the shirt is the only thing that she had any awareness that she was impaired in regards to.
Did the officers actually have reasonable and articulable suspicion to stop either of these young women?
No, Your Honor. There was no reasonable articulable suspicion here.
They're both coming out of the apartment building where they know, the officers know Patel is located and lives, and he entered 20 minutes before they left.
That's true. However, one of the women had entered before Agent Jones had even started surveillance. She wasn't sure when that woman had entered. Moreover, they weren't sure where inside the building these women had gone. They simply knew that they had gone inside a building. One apartment in that building was owned by rented by Mr. Patel.
And so your view would be there was no reasonable articulable suspicion as regards either individual?
No, Your Honor. There was no reasonable articulable suspicion to stop either one. And
So
even
absent the mistake, you think this should have been suppressed?
correct. There was no articulable. The reasonable suspicion standard is based specifically regarding articulable facts that specifically relate to the person in question, or in this case,
So there's not really a Leon issue here at all. It's just a basic issue of reasonable suspicion.
yes, even if there, there was no reasonable suspicion. So on that regard, this should be suppressed because there was no specific articulable suspicion that those individuals were in fact engaged in a criminal enterprise.
So if Mr. Mendez had stopped Ms. Evans and everything else had transpired the way it did, you would have suppressed that search.
Yes, Your Honor. There was no specific indication that that the woman who was stopped was actually engaged in a criminal enterprise or any type of criminal activity. In particular, what Agent Mendez observed was a series of behaviors that were just as likely to be carried out by an innocent individual who was being followed by someone who she didn't know at dusk on campus. So,
Well, isn't this just a Terry stop?
it is that is correct, Your Honor. It's a Terry seizure of the bag.
And properly so. A proper Terry stop. They stop the individual, they have a brief conversation, they find out her identity, she refuses to deal with them or give them any permission for the search of the backpack. She leaves the backpack and goes on her way.
No, Your Honor, it's not a proper Terry stop because the Terry stop is dependent on having specific facts and specific articulable suspicion. In this
So what's
case,
the difference between a Terry stop and reasonable articulable suspicion?
reasonable articulable suspicion is the requirement to have a valid Terry
So
stop.
it's the same thing.
Yes, Your Honor. There must be that reasonable specific suspicion that there are, in this case, that there was some kind of contraband in the bag in question. Agent Mendez did not have any suspicion regarding the bag in question until after he had detained it. He needed to have some type of specific suspicion in order to detain it, in order to be able to rely on the Terry rationale and investigate his suspicions. He didn't have the specific suspicions that were required to even detain the bag in the first place.
Well, we've upheld cases where all you have is a car leaving a known drug city, and the car appears to, be dragging a little bit in the rear. So there's something heavy in the trunk. Reasonable articulable suspicion.
Yes, Your Honor. In those cases are potentially reasonable articulable suspicion. However, in this case,
How's that different from our case?
in this case, we have the woman leaving a house, an apartment complex, an apartment building, where there was a known drug dealer who lived there. But it's not a source point. It's not like it's a source city, as in the cases that you mentioned.
Well,
this is just a
much
house.
narrower than a source city. It's an individual.
It is narrower. However, a source city implies that it is in fact a consistent, reliable source, that there's some evidence that there's any drugs coming out of there. The only information here is that Mr. Patel lived in this apartment. Mr. Patel was under investigation for this drug activity, but there was no indication or definitive evidence that he was in fact running some type of a drug ring. So that situation is slightly distinguishable. Fundamentally, this Court's consistent and unwavering application of the good faith exception has been specifically limited to cases in which the police officers in the field didn't in fact make the mistake and did rely on the neutral third party. And Herring did nothing to change this fact. In this case, the mistakes that were made by both Agent Jones and Agent Mendez were by the police officers that were in the field. Therefore, based on that alone, it is inconsistent with this Court's jurisprudence.
If it's a good faith mistake, what difference does it make to Lindsay?
The difference is that when a third party, a neutral, impartial third party that's not in the field makes it, for instance in Leon, a magistrate, that person is not engaged in the particular competitive enterprise of ferreting out the crime. They don't have as much of a stake, therefore their incentive to deter the Fourth Amendment is far less. And further,
The standard is an objective standard of good faith. What should that matter? Are you suggesting that courts can't figure out what objectively is good faith?
the standard is, it's called the good faith exception, but that is in fact a misnomer because it's based on objectively reasonable behavior. And the key in applying the good faith exception that this Court has laid down is that it's objectively reasonable to rely on a neutral third party. If that party makes a mistake that you don't know about, then you don't need to, then this Court has held that suppression is not necessarily required because the police in the field, the police who the good faith, or excuse me, who the exclusionary rule was designed to deter, didn't make any mistake in particular. However, in this case, that's not the situation. In this case, the police officers in the field did make a mistake. Both individuals made mistakes, and therefore the fundamental factual predicate for the application of the good faith exception is not present here.
But couldn't Mendez reasonably rely on the information given him by his partner?
Agent Mendez...
He doesn't really make a mistake, does he? I mean, he relies on the information that he is given and does what basically he's told to do, stop that person who is described in that fashion.
Yes, Your Honor. As a general matter, the police are entitled to rely on the observations of fellow officers, which is initially what Agent Mendez was doing. However, in this case, Agent Mendez had followed Miss Evans on multiple occasions before. He was aware of her appearance, and he doubted that the person he was stopping was, in fact, Miss Evans. Now, he is not entitled to rely on an officer despite his own misgivings based on his own personal observations.
So what should he have done?
He could have done several things. The easiest solution would have been to radio back to Agent Jones and try to ascertain the identity of the person in question. Agent Jones was around the corner nearby. She could have come over and identified the woman who was being stopped, and that wouldn't have involved the color of her shirt when she had an up-close identification looking at the woman, so her color blindness wouldn't have been impacted. That would have been the more prudent course of action for Agent Mendez to take. Instead, he just went ahead and went on with this course of conduct despite his misgivings without actually resolving the identity of the person. And even after he had stopped the woman, the ambiguity was magnified because she gave the name Abigail Pierce, which was not the person he was supposed to be following. And he stated specifically in his deposition, he didn't know what was going on. He said he didn't know who he was stopping. And he was thoroughly confused by the situation. So he should have done something, for instance, talking to Agent Mendez.
But the stop was very brief, correct?
Yes.
And the conversation very brief.
Yes.
And she's permitted to go on her way.
Yes, that's correct.
So where's the big Fourth Amendment violation we're trying to ferret out?
The Fourth Amendment violation as it regards to Agent Mendez is in the detention of the bag and not allowing her to take the bag.
So the bag has Fourth Amendment rights now?
There is a Fourth Amendment violation when personal property is detained without a specific reasonable articulable suspicion that there's some type of contraband in the bag.
But you have the dog sniff.
We do have the dog sniff, but however, the dog sniff occurred after the detention. And as I stated a moment ago, it's important.
But it's all part of the same situation. She hasn't even left to go on her way by the time the dog arrives and does the sniff.
Well, the dog arrived approximately 2 or 3 minutes later, but nonetheless, Agent Mendez still did not have specific articulable facts that would lead him to believe or lead a reasonable person to believe that there was any contraband in this bag when he
before
looked
the
at
dog. Yeah, before. After
yes,
the dog
before the dog sniff. And
with us, dog sniffs are sacred.
And fundamentally, that is the key, that suspicion needs to be present in order to justify the brief detention, in order to bring the dog so that the dog can confirm and further the suspicion that the officer has.
Let's get this straight. Do you concede that the original encounter was consensual between Mendez and Pierce?
Yes, sir.
Okay. Then you don't believe, however, that she consensually allowed him to maintain a backpack. Your argument is he seized that against her will, right?
Yeah, he told her that he was going to detain the bag. From her perspective, there was no option.
He didn't say you can take it if you want to.
Yes, sir.
Where do the dogs come in that particular set of time?
Well, the dogs come in after the fact, after that.
She's already gone.
She's leaving or has left. Yes, Your Honor. The detention had already occurred based on simply inchoate and unparticularized suspicions of activity that.
If we had greyhounds instead of basset hounds, then maybe this thing would be okay, but we don't because the dogs get there a couple minutes later.
There might be a slightly different scenario in the case if the dog was in fact there or had arrived just moments later, but there was a several-minute gap after the initial detention until the dog actually arrived.
But she was still present.
I'm sorry?
She was still present.
I believe she either left or was leaving because the 3 minutes had elapsed and she had
According
said,
to the record counsel, she was still present. Cricket started her search while the girl was still present. Cricket being the dog.
right. Yes, that's correct if that's what it says in the record. But nonetheless, this particularized suspicion that was required to make the initial detention wasn't there. And again, that is fundamentally the key inquiry for this
So
court.
they had it later, but they didn't have it when they stopped her.
They did not have it initially when they stopped her. Furthermore, to briefly conclude, the application of the good faith exception in a case like this, as the petitioner would contend, would fundamentally threaten to swallow the exclusionary rule and would turn the good faith exception into the good faith rule. It would be a predicate aspect of any Fourth Amendment analysis. I see my time is expiring, I have to leave. It would be a fundamental predicate aspect of any Fourth Amendment question to analyze this good faith exception. That is not what this court designed the good faith exception to do, and that's not how this court has applied the good faith exception during its jurisprudence.
Thank you.
May it please the court. My name is Daniel Poehler, counselor for the respondent, Abigail Pierce, in this matter. The 13th Circuit properly applied the apparent authority doctrine for the following two reasons. First, prior to Agent Harlan commencing his search, he knew in advance that he would be doing an unfettered search of Ms. Pierce's computer system. He was therefore required by the apparent authority doctrine to also have a reasonable belief that Ms. Lee's access to the system was unfettered. But Ms. Lee expressly told Agent Harlan that her access to the computer system was limited to Ms. Pierce's school documents. He therefore had no such reasonable belief.
Counsel, petitioner argues that when Ms. Lee said we exchanged passwords, that was enough to alert the officer that, or pardon me, to leave the officer with the reasonable conclusion that she did have that sort of unfettered access. Why do you disagree with their characterization of that?
For several reasons, Your Honor. First, because in the computer search context, when a government agent knows that he will be doing an unfettered search of the computer system, and secondly, B, that folder-level password protection exists on the system, the existence of folder-level password, or that knowledge, means that the agent has, it's a virtual per se factual ambiguity as to the third party's authority to consent. And several circuits have...
Under your scenario then, should the officer have asked some more questions? And if so, what questions should the officer have asked?
He should have asked some more questions, Your Honor. The apparent authority doctrine, as applied in this case, would require that the officer have a reasonable belief that Ms. Lee's authority over the computer system was unfettered. And this is because the officer was going to perform an unfettered search. It would have been extremely unburdensome for the officer to determine the scope of Ms. Lee's authority over the system, because whenever an officer is performing an unfettered search, all he needs to do is simply ask, is your authority over the computer unfettered? In this particular case, Ms. Lee would have simply said no, resolving the ambiguity.
Assuming she knew what unfettered.
Oh, yeah, assuming assuming that, Your Honor. But in any event, the issue of resolving the ambiguity would have been extremely easy for the officer, and in fact, that's the case in the typical situation in which the officer...
Well, in the 10th Circuit, the fine circuit that we have in our there's a case called Andrus. Are you familiar with that?
I am.
Doesn't that case cut against your argument that the officer should make further inquiry?
It does, Your Honor, but it also is the case that illustrates the importance of agent knowledge of password protection. In Andrus, the court said that it is a critical fact in the determination of apparent authority whether the officer knew or reasonably should have suspected that password protection existed on the system.
So just don't ask too many questions. Go ahead and hook up your search systems and away you go. Is that how you should function?
That is not how you should function. And in fact, that's the perverse incentive that is created if we do not require government agents that are faced with ambiguities, such as in this case, to inquire and determine the third party's extent of the third party's authority.
But in Andrus, there was no next question. There was no question about unfettered access.
That is true, Your Honor. However, there were other...
All it was there's a computer, or there's a computer and it's my son's, and I have access to his room, and that was about it, wasn't it?
That is certainly true, Your Honor. However, in Andrus, there was never any indication to the government agent that password protection indeed existed, as in contrast to the case at hand. Password protection has been found by several circuits to be an exemplar of a factual ambiguity, especially in the computer search context when folder...
So that's a red light. So the officer should stop?
It is absolutely a red light,
And do
Your Honor.
what?
and inquire and determine the extent of the third party's authority.
So here we find out that the roommate Lee had authority. She had the password.
We found out that Ms. Lee had authority to a single folder on Ms. Pierce's computer. However, when folder-level password protection is being employed on a system, the third party's acknowledgement that they have access to a single password is in no way dispositive that they have a password or access to any other folder on the system. This was acknowledged by the Fourth Circuit in Trulock v. Gray when it held that a government agent, that a third party and the defendant shared use of a computer, but nevertheless maintained separate password protection over their files and folders, resulted in an unconstitutional search when the government agents bypassed the password protection as Agent Harlan did in this case. Furthermore, even though there is a relative paucity of Fourth Amendment jurisprudence regarding password protection in the computer context, there are various circuit court cases that have held that it was both rational, that have held that Fourth Amendment privacy analysis can be rationally applied at the computer search level, and that discrete privacy expectations can be found at the folder and file level. For example, in Trulock v. Frey, as I mentioned, but also in U.S. v. Carey, another 10th Circuit case, the court held that just because a government agent has authority to search a computer hard drive generally does not give carte blanche authority to the government to search the individual files and folders on the computer. And to the extent that the government exceeded that authority, the search was unconstitutional.
Counselor, the petitioner argues that if we would have allowed or would have required the officers to conduct get a search warrant, that the data on the computer could have been manipulated. What's your response to that?
I think that response strains credulity, Your Honor, because while it's true that ones and zeros are a somewhat dynamic environment in the computer context, computer files and folders are commonly known to hold files, hold data, and not really be at a big risk of corruption or anything like that. And in any event, the underlying issue here is whether or not Agent Harlan whether or not it appeared to Agent Harlan that Ms. Lee had the apparent authority to consent to a search of Ms. Pierce's computer.
Counselor, do you care at all that there are students dying on this
I
campus?
do certainly care about that, Your Honor, and that is a matter that Respondent takes seriously. However, the issue here is one of Fourth Amendment jurisprudence, and if Agent Harlan was unable to have a reasonable belief that Ms. Lee's authority extended over the entirety of the computer in an unfettered manner, he was not able to constitutionally perform an unfettered search of the computer. At that point, he was required to either resolve the ambiguity in favor of Ms. Lee's unfettered authority, proportionately delimit the search to Ms. Pierce's school folders and the folders that Ms. Lee did have access to, or terminate the search altogether. And Agent Harlan did none of these things. The search was therefore unconstitutional.
Do we know whether at that point Ms. Pierce had been arrested?
No, we don't know at that point whether Ms. Pierce had been arrested, Your Honor. In any event, what Agent Harlan knew at the time was that this was not Ms. Lee's computer, that it was a desktop, and while it was turned on, as is the case in U.S. v. Andrus and in U.S. v. Buckner, where apparent authority was found, there was a clear indication that Ms. Lee's authority over the computer, that the scope of her authority was limited to Ms. Pierce's school documents for emergency purposes, and moreover, once Agent Harlan, and even if it's found...
Well, but let's take this back to what you think should have happened. Agent Harlan discovers that the particular folder is password protected. He asks Ms. Lee about that. She says, yes, we got this program. But then she says, we exchanged passwords. Now, what should Harlan have done next, in your opinion, to satisfy the Constitution?
He should have continued to inquire, Your Honor.
What should he have asked?
He should have determined
Do you really mean it? Or, I mean, what's the next question?
The next question is, what is the scope of your authority over this computer? Is it unfettered or unlimited, or is it limited in some way? And the reason
Would that really be likely to get any more meaningful information to ask a question like that?
It would have made all the difference in this case, Your Honor. Agent Harlan intended to perform an unfettered search of the system. By asking whether or not she had unfettered access to the system, he was not only seeking to determine her actual authority, which is the right result under Fourth Amendment jurisprudence, that the scope of the agent's search does not exceed the actual authority of the consenting third party. But he would have also been able to ascertain that he would not have been able to use the unlocked software, that he would have had to have further define what the scope of her authority was, and that he would at that point have had to either say, well, this search is not worth it and I should go get a warrant, or proportionately delimit the search. And notice that that is an extremely light burden for the government agent to meet in this case. I mean, and the crux is really that the government agent comes into the situation intending to perform an unfettered search.
I don't, you keep saying that. I don't know if that's within our facts. I mean, he asks if he can enter the apartment. He finds out if he is an occupant of the apartment. He asks about computers. I think, there were hopes and dreams that things would be found, but I don't think it was his intent when he crossed the threshold.
It may not have been.
He's just investigating.
Yeah, he didn't even really know that she had a desktop computer in the premises at the time. But when he commenced the search of...
You speak of it like malice aforethought, and it's really, we really don't have those facts here.
I certainly don't intend to imply that he had malice or forethought in this situation. But when he when he began the computer search, all of his actions suggested that he was not going to be doing a one-by-one, file-by-file search. Rather, the first thing he did was begin to shut down the computer so that he could hook up the unlock program and perform an unfettered search of the system. And that is fundamentally what the unlock program does. Even when he found out that folder-level password protection existed, he continued, and he ascertained that Ms. Lee knew the password to that particular folder. He proceeded with the unfettered search of the computer system.
What if he'd have followed up and said, when you say you changed all the passwords, does that mean you have access to all the folders? And Ms. Lee mistakenly, being unaware of the debate team folder, had said, well, yes, I do. And then the officer hooked up the unlock program. Would that make a difference?
It very well may, Your Honor. As this court has held in Georgia v. Randolph, the Fourth Amendment jurisprudence is not amenable to bright-line rules, and therefore totality of the circumstances analysis is required. If it reasonably appeared to Agent Harlan that Ms. Lee's access to the system was complete and total, he could have proceeded with the unlock software and done an unfettered search of the computer system without a doubt. However, in this particular case, he did not have a reasonable belief that Ms. Lee's authority over the system was so extensive. And the difference between system-level passwords and folder-level passwords can be instructive in this regard. If a government agent knows that a system-level password is being used and the third party offers up that password, it may be reasonable for the agent to assume that the third party has unfettered access to the computer system. But it's a fundamentally different situation when the government agent knows that folder-level password protection is being used, because that's like looking at a dresser.
But she had a password to a folder.
She did, Your Honor.
So couldn't the agent say, well, okay, maybe that password goes to all the folders? I mean, why do we assume that every individual folder has its own password?
Agent Harlan knew that Folder Protect Expert gave Ms. Pierce the ability to uniquely protect her folders on the system. And
she had the ability, but did we know, or did he know, or did the roommate know that in fact she had done that?
I think that it was unreasonable for him to believe anything else. The roommate certainly knew that Ms. Pierce had employed multiple folder-level password protection on the system, and that she did not have access to any of those folders or files. Agent Harlan decided to search the system despite the fact that he knew that folder level password protection existed, which is like looking at a dresser bureau, getting authority to search a single drawer in the bureau, even while you know that each individual drawer on the bureau has its own unique key, by virtue of the fact that the third party provides a single key.
Should we be taking more care and concern here where this sort of computer program is used by the authorities, that if we had a search that had been folded by sort of individual clicking on folders in some sort of manual fashion, is there something about that software program that should give us more concern?
I don't think so, Your Honor. I think there's nothing fundamentally wrong with the unlock software. I think the real issue here is whether or not Agent Harlan, it does come to bear when ascertaining whether or not Agent Harlan, and I see my time is up, may I briefly, it does come to bear when determining whether Agent Harlan did have a justified or a constitutional search in the matter, because in order to validly perform such a complete search, he had to reasonably believe that her access was complete before commencing the search. If he had no such reasonable belief, he had no apparent authority. And to hold otherwise would be to overturn Rodriguez. And for these reasons, we would ask that the 13th Circuit is affirmed. Thank you.
Mr. Grise, I'd like you to start where Mr. Buller stopped. And that is my question concerning the use of this particular software as something that should cause some heightened concern on our part about its potential intrusiveness without more questions being asked, so to speak. How would you respond to that?
Your Honor, certainly the use of this software without any inquiry and with the surrounding circumstances presenting ambiguity would create an issue. The Fourth and Sixth Circuits have specifically spoken to the fact that the use of this software where it is being used intentionally to bypass known passwords would not work and would be a workaround the Fourth Amendment, which is why the Agent Harlan in this case acted reasonably when he was confronted with a password prompt. He asked questions, confirmed authority in the folder, and resolved the ambiguity around this password. He should not be charged.
Just to that folder.
Yes.
Just to that folder.
Yes, Your Honor, but he should not be charged with the knowledge of how fully the Ms. Pierce utilized this software. Similarly, installing Microsoft Office on a computer does not necessarily
Shouldn't he have at least manually attempted to open another folder to see if there was again a password prompt?
Your Honor, that would not have been reasonable under these circumstances. He was confronted with a password prompt. He responded appropriately. He confirmed authority. He was not aware of any other folders and unfamiliar with this software.
He didn't confirm the breadth of the authority. That's the problem.
Pardon, Your Honor?
He didn't confirm the breadth of the authority.
Respectfully, Your Honor, he did confirm the breadth of the authority. She consented to a search of the computer, the container. She said she used the computer 2 to 3 times a week. It was turned on when she entered the room. And when confronted with a password prompt, she had the key, she had the password, and she had authority in that folder. To any reasonable officer, this would have been, Your Honor, I see my time has expired. May I have leave to finish? To any reasonable officer in the field, in a rapidly unfolding investigation, these facts to him reasonably indicated that he had confirmed authority, and to hold otherwise would be essentially carve out an exception for personal computers and saying that you can't have apparent authority on a computer. This is a prime case for applying this doctrine to these facts. Thank you, Your Honor.
Thank you, Counsel. This case is submitted. We appreciate your arguments this afternoon. The court will briefly adjourn and then return with our decision.
All rise. This honorable court is now at recess.